Does getting permanent resident status in Canada automatically means you have to pay Canadian tax on everything you earn worldwide? Short answer, no. And one tax court case shows exactly why. Let's look at the Cecilia Wang versus the Queen, a Canadian tax case that helps explain the difference between immigration status and tax residence. Mrs. Wang had what used to be called landed immigrant status. Today, we call it permanent resident status. A lot of people assume that once you become a permanent resident, you automatically become a Canadian tax resident. But that is not necessarily true. In this case, Mrs. Wang came to Canada in 1998 for education and training. She was employed by Duracell China, and while she was in Canada, her employer paid her schooling and living expenses. Now, on the surface, it looked like she had some meaningful ties to Canada. She had a rented room in Canada, a car, a Canadian driver's license, a Canadian bank account, and landed immigrant status. So, the theory's position was basically, she is in Canada. She has immigration status. She has Canadian ties. So these amounts should be taxable in Canada. But the court did not stop there. The judge looked at the full picture. Mrs. Wang still has stronger ties to China. Her family was in China. She had housing available there. She owned an apartment in China. She had a Chinese bank account and credit cards. And she kept personal belongings there. Chinese income tax was paid on her behalf. And most importantly, she remained employed by her Chinese employer. The court asked the real legal question. Where was she resident for tax treaty purposes? Under the Canada-China tax treaty, if someone appeals connected to both countries, you look at where their personal and economic relations are closer, sometimes called the center of vital interests. And the court decided that Mrs. Wang's closer ties were to China, not Canada. That alone is already an important lesson. Immigration status does not decide tax resident by itself. But there was a second issue too. The court also looked at whether she was in Canada solely for education or training under the treaty. Even though she had landed immigrant status, the court said the status alone did not prove she intended to settle permanently in Canada at that time. Instead, the fact shows she was in Canada mainly for training connected to her employment. So, the result was that payments she received from her Chinese employer for maintenance and education were exempt from Canadian tax. Mrs. Wang won her appeal. So, what's the big takeaway from this case? Your immigration status and your tax status are not the same thing. You can be a permanent resident for immigration purpose, and still have a strong argument that you are not a resident of Canadian for tax treaty purposes, depending on your facts. What matters is not just your visa or PR card. What matters is where your home is, where your family is, where your economic life is centered, and what country you are really most connected to. So, if someone says, once you get permanent residency, Canada automatically taxes all your worldwide income, that is too simplistic. Cecilia Wang versus the Queen shows that in Canadian tax law, the answer depends on the facts, the residential ties, and sometimes the tax treaty.